प्रोडक्ट्स जो खाने में पौष्टिक तत्व की कमी को भर देते हैं। आई सर्टिफाइड वेयर फूड इज फोर्टिफाइड।
नमस्कार. आयच्या ह्या खाशेल्या डिबेटाक तुमकां सगळ्यांक येवकार. आनी ऑब्वियसली आयचो विशय आसा तो म्हळ्यार हायकोर्टाची फोंडा बाय इलेक्शना वयली ऑर्डर एनालायज करप. आनी आज म्हजे बरोबर अशी पॅनल आसा की म्हाका कसलेच कायद्याचें तरी टेन्शन ना, सुशेगाद रावपाचें आनी आयकुपाचें. अशे 3 पेजाद पॅनलिस्ट म्हजे कडेन आसात, 3 आदवोगाद आसात म्हजे बरोबर. आनी तातूंतले पयली जे आसात सिनियर लॉयर, म्हाका सामकी एक गजाल दिसता जाणी ही पिटिशन आर्ग्यू केलें आनी जाणी हे पिटिशन आर्ग्यू करून हे इलेक्शन स्टॉल केले. सरदेसाय बाब, वेलकम टू द स्टुडिओ. दुसरे आसात म्हजे बरोबर सिद्धार्थ बाब सामंत, ते कितें म्हणटात ह्या विशयाचेर ते आमी जाणून घेतले. आनी तिसरे आसात म्हजे बरोबर क्लियोफात बाब कुतीन, जेही कितें म्हणटात ते आमी जाणून घेतले. सो हांव तुमचे कडच्यान सर स्टार्ट करता. तुमी आज हायकोर्टां आशिल्ले आनी हायकोर्टां आसतना तुमी आज म्हाका दिसता CCP इलेक्शनाची पिटिशनाचेर तुमी थंय उबे राविल्ले. सो काल पयर तुमी एक इलेक्शन आडायलें आनी आज तुमी CCPचें इलेक्शन कित्याक आडावप न्ही हाजेर थंय आर्ग्यू करून स्टुडिओ भितर आयल्यात. सो म्हाका सांगात हे दोनूय रोल तुमी कशे करतात आनी ही जी ऑर्डर आसा ती ऑब्वियसली तुमी पिटिशनराच्या फावरात आर्ग्यू केल्ले. हाव आर यू एनालायझींग दीस ऑर्डर?
बरो प्रश्न केलो तुमी. आमी वकील म्हणजे बेजिकली भटां भशेन आमकां बारसोय लागता, राद्दूय लागता. सो जे जे मॅटरीक आमकां आपयतात ते प्रमाणे आमी ते आमचे मंत्र म्हणटा.
आनी हाव आर यू एनालायझींग दीस हायकोर्ट ऑर्डर जी आयली? तुमी ताज्या हातूंत पिटिशनराच्या फेवरान आर्ग्यू केल्लें. 2 गजाली आहात. एक ऑन पॉयंट ऑफ लॉ आय थिंक द ऑर्डर इज व्हेरी क्लियर. आय थिंक द कंटेन्शियस इशू इज द टायमींग ऑफ द ऑर्डर. तुमी कशें पळयता हाका?
Frankly, timing should not matter according to me whatsoever, because see, the matter came to be argued on Thursday. There was a long weekend, and if you consider that there was a long weekend, the learned judges had only about 3 days to decide a matter wherein a lot of case law was cited, voluminous material was placed before the court. So in all fairness to the learned judges, this time that they took to pass this order cannot be found fault with. But having said that, I'm sure that there is going to be another opinion.
क्लियोफात बाब, तुम्ही कशी पळयतात?
On see, I agree with Nitin that timing is not an issue at all. But आमगे हायकोर्टानूय मुगे भाशेन व्हडलेश कांयच डिसायड केलें ना. Because आमगे हायकोर्टान has only followed a division bench judgment from Nagpur, that Sarodi judgment which was used, and the question was whether our High Court should follow that or disagree with that view and refer it to another bench. And the High Court took a view that it is following that judgment, and that is the view of the High Court.
What about the timing?
As far as the timing is concerned, that is what I am saying. The timing did not matter in this issue at all, according to me, because if the election is null and void, then it is null and void. Even if the election was conducted, then it would be null and void. It would be null and void, say 10 days before the order came, it would be null and void. But my issue is not exactly this. Though I would not sort of agree with that interpretation which is given by the High Court. But at the same time, I feel that the High Court was under a judicial discipline of following the other judgment, which was cited before him, and the High Court has followed that judgment. Possibly there was another view that was possible in this matter, but they thought that this is the view they should follow, that is by way of judicial discipline. Muge Bashin, a big injustice has been done to the Ponda electorate. For more than 1 year, they shall go unrepresented. Secondly, the judgment cited by them is a 2019 judgment. And a 2019 judgment is there for such a long period. The high courts are taking a different view, but the Bombay view is there for a long period. Now, having known this view, I don't think the Election Commission can justify a 5 months delay in announcing the poll.
Okay, I mean,
See,
yeah.
because this is very serious. I can understand if for the first time such an interpretation has come. This interpretation is there before the
Yes.
High Court,
And Election
being
Commission
there,
was aware about it.
they were aware of it.
Yeah.
They were aware that such interpretations can come. They are aware that there's a judgment of division bench, and still they keep quiet for a period of 5 months. In fact, whatever they have done is unpardonable.
ओके हांव ह्याच मुद्द्यांचे ह्याच आमी सिद्धार्थ तुमचे ओपनिंग रिमार्क्स घेता आनी मागीर नितीन बाबा मारा वता फॉर डिटेल्ड हे सांगात.
I have a slightly different take on it.
हय
According to me, whether it is Sarote's judgment, whether it is Duble's judgment or Govt's judgment, कसलोय judgment घ्या, interpretation of a statute, it doesn't clearly says that in express term, it does not say that minimum 1 year has to remain. Of course, it's an interpretation of the court, and continuously that has been followed. But any interpretation that comes in a way of giving voice to the people, giving representation to the people, I may not concur with it. I may not agree with it. According to me, voice of Fondekars, whether it is for 6 months or 1 year in assembly, is sine qua non. Any judge, of course, I am not criticizing. I am not saying High Court should not have passed it or they have erred in passing it. According to me, any interpretation which is stopping Fondekars from raising their grievances or participating, तांचे इतले प्रश्न आसूंक शकता. आता next 1 year कोण मांडटलो ते?
Okay.
What will be the voice of Fondekars in this?
Okay.
So according to me, this hits the very foundation. According to me, this is very basic and against the very democratic fundamentals itself. So therefore,
हांव ह्याच मुद्द्याचे नितीन बाबा मारता विल गो इन टू द डिटेल्स ऑफ अदर पॉइंट. नितीन बाबा तुम्ही हे एग्री करतात दॅट ओके पॉइंट ऑफ लॉ ही एक मुद्दो जालो बट दिस अल्टिमेटली लीड्स टू ग्रेव इनजस्टिस टू द पीपल ऑफ फोंडा.
आता first and foremost, let us not go by fractionalizing it, that Ponda people, Margaon people. The government which is in power today is government of the people, by the people and for the people. And if I mistake not, the government is in respect of the entire populace of Goa. So you can't really say that, well, now that there is no representative for Ponda and therefore they find themselves as orphans, which I strongly disagree with.
दुसरी गजाल जो इम्पॉर्टंट पॉइंट हा जो क्लियोफा चबाने काढलो, who is responsible for this fiasco? One thing, this is a fiasco. 18 hours before the voting begins, election is annulled. तुम्ही कोणाक responsible धरतात नितीन बाब?
Frankly speaking, see, it is one of our cardinal principles of law is nobody should be castigated without giving them a free and fair hearing. Now there is nobody representing the EC here.
Yeah.
If you go by that, someone should have been from the EC.
Yeah.
And that's when we would have got an answer.
Yeah.
Now today, unfortunately, our panelists, though are all erudite lawyers, and many of them are also in political analysts in this,
Yeah.
there is nobody to defend EC. So I feel that we should not condemn them unheard.
बट हांव मातसो वेगळे तरेन विचारता प्रश्न तसो जाल्यार डू यू थिंक इलेक्शन कमिशनान हो पॉइंट ऑफ लॉ लक्षांत घेवन 5 म्हयने रावपाची गरज नाशिल्ली नितीन बाब?
No, but again, we don't know 5 महिने तांकां कित्या खातीर लागले. There has to be some explanation. आता affidavit जे फायल केल्लें आसा before the High Court does not explain this delay. But it is not, you can't, it's a constitutional body. it's a body which is independent. So they must be definitely having some reasons. Perhaps if, as I don't want to repeat it, someone was here, they would have placed that material before you.
क्लियरफात बाब तुमकां दिसता हातूंत भितर सगळ्यांत चड एम्बेरेसिंग सिच्युएशन कोणा खातीर इलेक्शन कमिशना खातीर काय सरकारा खातीर
This is now you are going from law to almost to politics.
ना तुमकां तुमचे दोन्ही वाड्यांचेर पांय आसात अशें धरून चलता.
Okay. See, तुम्ही विचारलं म्हणून सांगता, election commission, Nitin does not want to say anything against it, but I would say election commission has got an egg on its face. Election commission should have acted with alacrity. And the very fact that they have not given any explanation for the delay looks like there was no explanation. We cannot read into what does not exist. One. Now, secondly, कोणा खातीर and कोणा बऱ्या पडलें. See, in 1989, elections were countermanded. तुका याद आहा कितें खबर ना म्हाका. And the countermanding was through a conspiracy. So, आता conspiracy na, but I see a design.
Okay.
And it is a purely a legal design.
Design without conspiracy?
Yes. There is no conspiracy because there a person who was about to die was taken, and that way it was a conspiracy. Magir Mundale Tegel bought all those type of things were there. Yes. So that here there is no but here there is a plain design. It was known that such judgments are there. Possibly the election commission was also moved for a delay. I do not know. Possibly after the results were announced, somebody realized that this can be helped for parties to get around it. Now I look at it as plainly the election helping the ruling party because their closed fist, how much is there inside has not been tested. Because if that was tested, maybe, I am not saying yes, it would be very difficult at election time in 2027. So it has helped the government.
Okay. मागे सिद्धार्थ बाब तुमकां सांगा, तुमकां दिसता फायनली नंबर वन, डू यू थिंक द डिले इज डेलिबरेट? कारण एक गजाल आसा, इलेक्शन कमिशनान हातूंतली एक जजमेंट तर सुप्रीम कोर्टाक चॅलेंज सुद्दां केल्ली ना. सो अशी न्ही की इलेक्शन कमिशन इज नॉट अवेअर. आणि दुसरी क्लियोफात बाब म्हणटात की दिस इज सर्टनली would have helped the ruling party म्हणून.
How, I do not know. I would not like to go into it, but I really don't understand how would it help ruling party? Because unless one knows for sure a particular person would not be victorious or only particular person would be victorious, and that is not to the advantage of, I do not know what is the idea that is being floated. I really wouldn't want to go. These are all guesswork. My guess is as bad as yours. But certainly, my case is that Fondekars have been crucified for somebody else's sins.
Somebody else.
See, EC has also argued, and EC has also whatever I could hear from arguments. See, there are just because see बाजारांतल्यान हाडून घराक पेंट कित्याक मारूना तुवें, चवथ केन्ना येतली तुका खबर नाशिल्ली हें म्हणप आनी इलेक्शन कंडक्ट करप, दीज आर नॉट सेम थिंग्स ऑफ सेम लेवल. इलेक्शन कंडक्ट करतलो पयलीं वेकन्सी अरोज जाता, ताच्या उपरांत तुजे वोटर्स लिस्ट रेडी जावपाक जाय, आनी इलेक्शन केन्नाय घेवपाक एग्जामी भुरग्यांच्यो एग्जामी असतात, तो रोल सगळे सफिशियंट टायम, आणि जेन्ना पळय 4-5 स्टेटीच्यो अश्यो बाय इलेक्शन जाता त्यो सगळ्यो एका दिसा जाता. सो आय डू नॉट नो, आय एम नॉट अ स्पोक्स पर्सन फॉर इलेक्शन कमिशन ऑफ इंडिया.
I do not want to give them benefit of doubt.
I do not know. They have to answer for. I do not know, but yes, these are the practical things. I have watched election closely. It can't be held just because people think you should have held it 1 month before, 1.5 months before, 10 days before. What would have happened if you were to hand it 20 days before? These things do not. I mean, it's not that as simple to say that if pointing the fingers is very easy. But my fundamental this is interpretations. Of course, the judgment was available as he says. They should have been challenged. Somebody should have gone, or if not, even now I am saying this judgment should. Of course, it has been already challenged. But I think a better interpretation of this is judgment, even if it is in the nature of operation successful, patient dies, I am fine with it. But a better
point of law settles
point
on
of law is
Supreme Court.
point of law is settled to say that democratic principles should be followed. The voice of people should not be curtailed just because this small embargo of saying that 9 months only have left, 10 months only have left. No amount of money, so much of money.
तुम्ही लोकांचा आवाज काढून घ्या
आवाज नका.
बरं.
आणि वन मोर फायनल गोष्ट, इतले पैसे खर्च जातले, वाय एक्सचेकर शुड बी बर्डन, सच आर्ग्युमेंट शुड नॉट बी. Voice of people cannot be equated with quantum of money that is spent. It is sine qua non. It is required for a healthy democracy. That's the setup we have accepted, and it goes against the very fundamental values of our democracy not to give a representation.
एक इंटरेस्टिंग मुद्दा आहे, आणि मागीसता नितीन बाबा काय विचारपाक लागता की हांगा स्टेटी पार्टी आशिल्ली, तातूंत भितर एक गजाल जाली की स्टेटीन एडवोकेट जनरलान उबो रावन सांगलें की ही इज गिविंग अ ओपिनियन एज अ लॉ ऑफिसर बट नॉट नेसेसरिली द पोजिशन ऑफ द स्टेट म्हणून, आणि तांणी तुमकां सपोर्ट केलो. सो वॉज दीस सामकें अशें शॉट इन द आर्म म्हणटा तशें, वेन द स्टेट फायनली सेज स्टेट इज नॉट एटलीस्ट नॉट टेकिंग अ पोजिशन कॉन्ट्ररी टू युअर पिटिशन.
आता पयलीं म्हणजे आय वूड लायक टू करेक्ट वॉट यू हॅव सेड.
या
It is not as if the learned AG has supported us. According to me, and I had said this earlier also, that the AG being the premier officer of the state is a constitutional authority. He can express his own opinion, divorce the opinion of his government. Now, when it comes to his own opinion, I personally feel that the AG analyzed the position of law as per his wisdom, and made a statement or made his argument based thereon. Incidentally, his argument coincides with that of mine. So, to that extent, of course, his argument was a shot in arm, but to say that you have supported and then...
support नहीं म्हणता तुम्ही.
It is, you can't say it's a support, it's a step. Ultimately, we all are discussing a question of law before the honorable court. And in every discussion, there is for and against.
Yeah.
So every time, it is not necessary that someone stands up for a petitioner. All the respondents in that petition will oppose the petitioner. There will be some playing a formal role. In this particular case, our entire petition was against the notification issued by the EC. So the main respondent in the case was the EC. And of course, they opposed us tooth and nail.
Yeah.
There was no relief against the government. So the government in that background was not necessary for the government to express any opinion. But the learned AG, feeling that this is a very important question of law, which actually needs to be settled, participated in these proceedings and gave his viewpoint.
एक गजाल बिफोर आय गो टू क्लियरिफाय, जो नितीन बाब जो सिद्धार्थ बाबान काढलो की अ मियर टेक्निकॅलिटी इन लॉ शुड नॉट, लोकांचा आवाज जो आसा तो दाबपाक जायना solely on a technicality in law म्हणून. How do you look at it?
With respects, I would disagree with Mr. Siddharth. The thing is, it's his perspective that it is a technicality in law. It is, according to me, not a technicality, it is on the merits of that matter. If the provision itself says that on the arising of a vacancy, election has to be mandatorily held within a period of 6 months. However, if the remainder of the period of that vacancy is less than 1 year, then the situation is different. Now, what is the technicality? It's a very provision which says so. Technicality would be on cases like, well, in a petition, we normally, the technicalities that are raised, well, you have not made somebody as a party, or so-and-so is not a state, therefore you can't maintain a petition against them, or some prayer is wrongly prayed for. These are technicalities.
You are saying this is a very
hardcore
issue.
Interpretation of hardcore law as it exists under the Representation of People's Act. And having said that, kindly note one more aspect. That 151A, proviso A that was sought to be interpreted by the High Court, or the interpretation which was followed by the High Court based on Nagpur judgment, is a proviso. That proviso actually highlights the main provision. That's what interpretation of statute says as far as proviso is concerned. So therefore, going by the law, it is not a technicality. It is very much the heart of the matter.
याच म्हणजे तुमचे मला आता क्लियरफास बाब स्टेटीचो जो स्टँड आशिल्लो आता तो स्टेटीचो स्टँड आनी तातूंत भितर आतां डिफरन्शिएट करचो पडटा
या
तुमकां तो पळयतकीर कितें दिसलें
चोय
हां
as far as Advocate General is concerned, he is certainly entitled to take a stand which he believes is the correct stand. But the state government ought to have taken a stand in the matter. So, in the famous minority rights case, that is the TMAPI Foundation case, Soli Sorabji told the government very clearly, I don't accept the government view. And Soli Sorabji represented the Attorney General and Harish Salve represented the government. So the government view was before the Supreme Court and the view of Attorney General was also before the Supreme Court. So according to me, the government who was a party there ought to have taken a stand and ought to have taken whatever stand they felt was correct, because finally they were a party to the petition and party to the petition had a right to take a stand. Now when the government and the Chief Minister says that they are shocked at the judgment, the government also did not kept quiet there.
हय सिद्धार्थ बाब आता जेन्ना एडवोकेट जनरलान हो व्यू मांडला म्हाका दिसता प्रामाणीकपणान हे ल्हानशें गोंय आमचें एडवोकेट जनरलान मुख्यमंत्र्याक सांगला आसतलें न्ही आपल्यालो हो व्यू म्हणून मागीर तांकां जजमेंट आयकतकीर शॉक बी कित्याक जावपा जाय बेश्टें आंग बी कित्याक काडपा जाय
I will. First of all, there are 2-3 things. One is, what is the current provision or proposition of law which is spelled out through these various judgment, interpretation of 151A. No doubt, I am also of the same view. I am not saying that 151A as of stands today, the judgment is contrary to the interpretation that has been given. So if Honorable AG जो view asa पळय तो correctच asa. If you ask me what is the present law on this, I will also tell you the same thing, or any lawyer also will tell you the same thing. The point that I was making is we have to take this forward and get this sorted out, so that, and the point that I was making is this is not technicality or something. This goes to the root. Why? I will tell you. At the time when the vacancy arose, there was good more than 1.5 years almost.
Yeah.
Somebody has delayed, whether it is EC, you pass the buck, EC हाच्याकडे दिवचे, ताणी आणि कोणाकडे दिवचे. It was possible to hold the elections within the mandate of 151A.
It was possible.
So therefore, that is what, whoever's fault it is, why should Fondekar suffer? That is what I am saying. For somebody else's sins, why Fondekars are being castigated or they are hanged? Why are they crucified? That is what I have been making point. Code, I am not saying the interpretation is wrong or judgment is wrong, or AG being a premier lawyer or government should have filed. All these things are right on their own way. I am not taking exceptions to any of these things. My only this is about democratic values, democratic principles and representation to the people. Jenka Ponekars must have a voice. एक वर्ष उरला, 3-4 sessions जातले. तांच्या specific Ponda specific question. Can you tell me which MLA is entitled to raise those?
बरें, म्हाका नितीन हो जो मुद्दो आसा आनी हो खूब जाण कालच्यान उलयतात की 1.5 वर्स जातले, कारण ज्या टायमार वॅकन्सी क्रिएट जाली थंयच्यान ऑलमोस्ट सारकी 1.5 वर्साचो काळ आशिल्लो. आतां इलेक्शन अनाउन्स करपाक आनी त्या रिजल्टाक डिले जाता म्हणून ऑल्दो 1 वर्स ताका मेळना आमदाराक, तरी कॉन्स्टिट्युएन्सी 1.5 वर्स अनरिप्रेझेंटेड उरता म्हण. तुमी कशें पळयता ह्या गजाली कडेन?
पळय, जे आर्ग्युमेंट केले इसीन हायकोर्टा फुडें, तांणी रिलाय जाले जजमेंटाचेर, जो प्रमोद लक्ष्मण गोदाडेचो जजमेंट आनी तो जजमेंट सुप्रीम कोर्टाचो. EC दिसलें की तो जजमेंट will help them tide over this difficulty. Now, so therefore, in good faith, they may have relied on the Supreme Court. Now, Supreme Court is always binding as compared to Nagpur bench. So they went by the Supreme Court. It's only to their misfortune. We succeeded in informing the High Court that Supreme Court can be distinguished on certain grounds. Now the High Court may have not even distinguished the Supreme Court, in which case the EC would have succeeded in this matter. See, in any matter, the High Court has to take its call one way or the other. So if it had to accept Pramod Gudadet's judgment, then EC would be well within its rights in doing what it did. Now that High Court has taken the view that we were prompting or we were requesting the High Court to take, in cold light of the hindsight, we can all say that no, EC has to be blamed, they are the rogues and all those things, which I don't feel now. This is all happening in hindsight. As on the date when the matter unfolds, both the sides come with their judgments and both the sides argue their matters. Now just coming back at, I am not, let me give a disclaimer first that I have got nothing to do with politics.
No, but you are free to express your views.
I know nothing about politics.
I love when lawyers express political views.
No, and let me just complete this. I know nothing about politics, and assuming without admitting that I know something about politics, let me candidly say I understand nothing about it. So, having said that, I would like to put myself on the razor sharp edge of law, and only just point out one aspect, because that is what an argument. But while doing so, I know I am treading on the borderline of politics and legality. But see, in this particular matter, any political party which felt should have had an opinion to air. It need not be the BJP, it need not be the Congress, it need not be the TMC. It could be anyone. Anybody. It could be RG or anyone. So whoever felt so much for the state of Goa as it being presented, that well, they went unrepresented, Ponda is being unrepresented. Now this is something not only to be fastened around the government of today. See, TMC was kind enough to file an application and intervene. Nobody stopped anybody from filing such applications. It is unfortunate that now that we come before this forum, and or otherwise every nook and corner of the state of Goa, everyone is castigating some party or the other, saying that it is your fault, it is their fault. In my respectful submission is, it is perhaps the fault of every citizen, because the courts don't bar any citizen also from coming here. A voter from Ponda could have filed. The persons who are otherwise involved in politics, irrespective of which party they belong to.
Yes, correct.
So
आज तुम्ही म्हणतात आज बोवाळ मारची परस तुम्ही जर त्यांना आयिल्ले तुमका रिप्रेझेंटेशन मेळटा आशिल्ले.
That is exactly what I meant in the cold light of the hindsight. This is the position.
You agree with this, Cleophas Bhav, ki this is a सामके तुम्ही आता म्हणतात नाही ruling party favor जाता, ruling party favor जाता, but this is also an abject failure of the opposition.
100%.
Nobody decided to intervene.
100%. But yesterday somebody asked me.
TMC intervened, which is not even contesting the election.
Correct. Yesterday somebody asked me, why did Congress party not intervene? They should have intervened. Then I told them that Baba, they got Rahul Gandhi convicted in Gujarat without a representation. So why are you asking me? They did it. So I mean, it is everybody's fault. They should have intervened. But the way I look at it, none of them took that this would take this turn. Looks like that, but you cannot take the court for granted in this form. It is everybody's fault. They should have, in fact, the candidates and the parties should have been more alert in this. More alert. You cannot absolve them of that responsibility.
सिद्धार्थ बाब जे TMC फाईल केले ते बाबडी कॉन्टेस्ट सुद्धा करनाशिल्ली इलेक्शन आणि ज्यो तीन पार्टी कॉन्टेस्ट करताल्यो त्यो आता रिझल्ट येतकीर त्यो आमकां प्रेस कॉन्फरन्स घेवन बोवाळ मारतात कितें जावपा आता तुतल्यान
कोणी इंटरप्रेट जावपाचे ना I cannot comment on it, but question is not limited to interference in this petition. I am about the meaningful reading of section 151A, and if as it is, it can't be read the way I was putting it, or way supports the democracy, way it supports the voice of the people in this, then it needs an amendment. Let Parliament should do it. Whichever government it is, Parliament should do it. Whether it is 6 months, whether it is 9 months, of course, it can't be 5 days before the election somebody dies, you should hold election. It can't be that absurd. But if there is a reasonable time from the day vacancy arises, elections must be held. It might be for 3 months, it might be for 6 months, it might be for 1 year. You have to give, either you give a meaning to it in the present framework or get that amended. Otherwise, it offends the basic structure of our constitution.
बरे मागे नितीन सांगात फायनल राउंड घेतना आज काँग्रेस सुप्रीम कोर्टाक गेल्या हांव सामकी कॉमन मॅनाची तकलेंतलो प्रश्न विचारता आज समजा सुप्रीम कोर्टान ताकतिकेन समजा हे पिटिशन काँग्रेसीचें आयकलें what can happen? Is it an academic petition, fully election खातीर, or can something happen with regards to Fonda? Or there is, कारण आता election commission नंतर notification issue करून election annul केलें. So for general public's understanding, what can happen now?
See, the Supreme Court on decision घेऊ येता maintaining the High Court judgment, or it can even disagree with the High Court. Now, for that, I have to just take a small detour to explain this. Maharashtra state in so government or the judgment जो आसा Nagpur so that is binding on Goa because we are common High Court with Maharashtra or Mumbai. आता हे issue chair judgments Karnataka, Punjab and Haryana and Assam's exactly opposite view asa. So although Goa bench had to follow Maharashtra, as far as the entire landscape of India is concerned, there is a difference of opinion expressed by difference of High Courts. So therefore, according to me, this law needs to be settled by the Supreme Court. And now that Congress has gone to the Supreme Court, I personally feel that the Honorable Supreme Court should catch the bull by the horn and decide this issue. Now coming to your question, whether this is academic or not, I feel that it is not academic. If the matter is, because see the Supreme Court also has got lot of cases to handle. If the Supreme Court is able to devote some time to this particular issue and it hears the matter before the so-called 1 year or before the next elections, which could be somewhere in March of 27, then the Supreme Court, by exercise of powers under Article 142, which is a power vested only in the Supreme Court, and that power says, 142 of the Constitution, which says that to do complete justice, it can order the Election Commission to hold elections and fix the timelines for doing so. In which case, it is quite possible that we'll have results upon the constituency. But then that is for the Supreme Court to take a call upon.
क्लियोफात बाब तुमकां कितें दिसता हे आतां समजा आयकल सुद्दां कितें जावपाक शकता म्हळ्यार समजा आतां आमी पळयलें की बाबा सुप्रीम कोर्ट कितें करपाक शकता एक तर ओके हायकोर्टाची ऑर्डर अपहोल्ड केली जाल्यार थंय आनी मागीर प्रॉब्लेमूच ना कांय जावपाचो समजा एक डिफरंट व्यू घेतलो कितें फोंड्या इलेक्शन जावपाक शकता आतां रिजल्ट आमगेले 4 मेक आसात ताज्या पयलीं कितें सुप्रीम कोर्ट ऑर्डर दिवपाक शकता
if the Supreme Court is pushed and they get time and they find that this is a point of importance requiring urgent attention, maybe even before the counting day, they ask the Election Commission to see if polls are possible. And according to me, as I look at it, if all their readiness is there, it is possible, but looks difficult because hearing will take time, notices will have to go. It looks difficult. But as Nitin said, the point requires to be settled. But I am more worried with the Election Commission not challenging the order, or at least right now. So far, they have not challenged the order, or they have not shown any indication that they are going to challenge the order. So it would have been better if the Election Commission had challenged the order. It would have been ideal. But this brings me to the point of my design. I do not know whether there was some design because they should have been the first person who should have challenged that order the next day.
Correct.
So I smell a design there.
सिद्धार्थ बाब तुमकां काय डिझायन दिसता काय फक्त डिझास्टर दिसता
No, I do not know what election commission is doing. Maybe तांचे विचार मंथन चालू आसा कशी चॅलेंज करप ग्राउंड्स कितें करप हाचेर करत आसत ते I will not be able to say anything. But now that the matter has reached the Supreme Court, election commission will be a party there and they will have to put in their defense whatever they want to say. And I hope this matter is taken to logical conclusion. Rest everything what Dr. Sardesai has said, I agree with, and I am wishful and hopeful that an order which supports the democracy, which supports the voice of the people, which gives representation to the people and brings fruitfulness to our democracy, because there are only two things. Either you can solve the grievances of the people through the assembly or on the streets. There is no
Okay.
third way in the this.
Jata.
So according to me, raising the voice, grievances, passing laws, or speaking about your grievances, assembly is the matured way of solving
बरें.
the thing. Not on the street.
फायनल नितील बाब एकच विचारता आनी हांव कंक्लूड करता कारण हो टेक्निकल प्रश्न आनी म्हाका दिसता देर आर सम पीपल तांकां इंट्रस्ट आहा की बॅलट वोटींग जाल्लें आनी ही जी पोस्टल बॅलट्स गेल्ली ती मागीर 117 आसूं किंवा 118 आसूं तांचे कितें करपाचें कितली बेगीन डिस्ट्रॉय करपा जाय ती आतां
ना ती मॅटर समज तर सुप्रीम कोर्टाक गेल्ली आसा
हय
जाल्यार ते प्रिजर्व करचेच पडटले टील द मॅटर इज डिसायडेड बिकॉज फाल्यां समज तर सुप्रीम कोर्टान सांगलें इलेक्शन्स घे म्हणून जाल्यार दोज पीपल कांट एक्सरसाइज देअर फ्रँचायज ऑल ओवर अगेन हा they have played their innings.
Yeah.
And as we know, there is never a second innings in a one-day international.
Correct. And our elections are ODIs.
Yes.
Our elections are ODIs. So हांव इतल्याचेर थांबता म्हाका खूब जाणांनी सोशल मिडियाचेर हो प्रश्न धाडिल्लो की तातूंत भितर म्हाका दिसता कांय जाण आसतले जाणी पोस्टल बॅलट्स दिल्यात की आमचे मतांचे कितें जातलें काय म्हणून कारण एक गजाल आमकां आज इतलोच उद्देश आशिल्लो की सामान्य जनतेक कारण जशें सिद्धार्थ बाबांनी म्हळें की हो फायनली तुमचो प्रश्न आमचो प्रश्न